But your concern actually is what is actually how the courts deal with the cases involving these encashment of performance bonds and mobilization advance bonds. I think least, minimal. Right starting from 1994 to onwards, our Supreme Court of Pakistan has been consistent. These contracts, these bonds, these bank guarantees, they are treated as autonomous, independent contracts. And we have always shown a policy of non-interference there. Now, there are two things. Bringing of an action to the court and then the action of the court to grant an injunction. There are two things. Unfortunately, because since arbitration or ADR has not been institutionalized in Pakistan, so people are actually encouraged to bring the cases to the courts to get a leverage for the reason if I am representing a contractor, when we used to practice, I think it's a choice of the client actually. What matters is they don't prefer to go to an arbitration. What their concern would be that, okay, go to the court, get us a injunctive order against a bank guarantee. That's the concern. But the problem with the courts is because the process of bringing an action to the court is quite liberal. It only costs a nominal amount of court fees. So actually the case comes to the court. But courts actually have showed reluctance in giving injunctive orders to these performance bonds and this mobilization advance bonds. However, speaking for myself and the courts, actually we have drawn a distinction between a mobilization advance bond and a performance bond. A mobilization advance bond is treated as a debt act, and the courts are actually zero tolerance. We don't actually interfere into that. However, the question when the dispute comes with regard to the encashment of the performance bond, actually the courts are liberal. Why liberal? For the reason that there is a question of determination that is there any default of a contractual obligation by the client or the contractor. There the courts actually are the policy of pro-interference. We interfere into that to determine that actually who is at fault and where is at fault. So I think as far as the bonds are concerned, we are not at all interfering into that. As far as the question of claim of price and time is concerned, the courts are not the forums for determining these contractual issues. Because I, speaking for myself, cannot decide a claim of damages actually. I can only review a claim of damages by looking at the law and the guidelines provided in terms of the Contract Act. But I cannot determine actually that what loss is actually being accrued to either the contractor or a client. So I think the courts actually, with regard to the claim of price and time, the matter when it comes to the court, it is already decided by an arbitrator actually. So what we have to do is either it has to be a question of enforcement of foreign award or the enforcement of a local award actually. So these courts don't actually decide, the courts only review the quantum of damages awarded by an arbitrator. First of all, if there is a CPAC dispute, what I have inferred is that there are adjudicatory boards to decide the difference actually. It's not actually a formal dispute. When the matter goes to an adjudicatory board, it's a difference only. And that's the first year where difference is resolved. If that difference is not resolved and is graduated to a dispute, then there's a mechanism of arbitration is available. And when arbitration is finalized conclusively and award is given actually, then the role of the courts are minimal only to an extent of enforcement. We don't go look into the merits of the quantification of the damages. We don't look into the invalidity of the contract. We don't go and look into whether the rupees 1,000 has been properly, is the actual loss or not. We don't determine what is a reasonable compensation. What we decide actually is a dispute within the four corners, fair enough, that's it.